Challenges to enforcing international law. The enforcement of international law faces significant challenges stemming from its unique decentralized structure and the inherent nature of the international system. Unlike national legal systems, international law operates without a centralized global authority, possessing legislative, executive, or judicial power. Key challenges to enforcing international law include A1. Absence of a centralized enforcement authority. 2. State sovereignty and consent. 3. Dependence on state cooperation. 4. Jurisdictional and conceptual issues. And 5. Political dynamics and power imbalances. 1. Absence of a centralized enforcement authority. The international legal system lacks a central government, a world legislature, or a global police force. This means there is no standing body of international law enforcement officers. Moreover, international law is a horizontal legal system where the functions of lawmaking, law determination, and law enforcement are all arranged horizontally, not hierarchically. This contrasts sharply with highly developed national legal systems that centralize the use of force and create sophisticated legal institutions. 2. State sovereignty and consent. International law is predominantly made and implemented by states. Its binding nature relies heavily on the consent and political will of states, meaning no state can generally be compelled by another state or an international body without its consent. States are often reluctant to surrender sovereignty to international organizations, which limits the authority of these bodies to compel individual states to follow international provisions. This is particularly evident with agreements that are voluntary in nature, such as the Paris Agreement on Climate Change. States can withdraw from international agreements or hold the threat of withdrawal over organizations like the International Criminal Court, ICC, if they are unhappy with decisions. Complicating enforcement efforts. The concept of sovereign immunity poses a significant obstacle, especially for prosecuting top officials. While Article 27 of the Rome Statute attempts to do away with official immunities, Article 98 tempers this by stating that the ICC cannot require states to break state or diplomatic immunity when requesting surrender or assistance without the third state's waiver. 3. Dependence on state cooperation. The ICC, for example, has no police force of its own and is entirely reliant on state cooperation for investigations, apprehending indicted individuals, transferring and protecting witnesses, and intelligence assistance. States frequently fall short of these responsibilities, even when international courts, such as the International Court of Justice, ICJ, issue judgments. Their enforcement ultimately relies on the willingness of states to cooperate and implement the required changes in their domestic law or policy. 4. Jurisdictional and conceptual issues. The ICC faces jurisdictional issues, particularly over non-party states, which it can only obtain through a United Nations Security Council referral if state leaders refuse to cooperate. The ICC's attempt to operate as a conventional criminal court, applying individual criminal responsibility in an international arena, traditionally focused on state interaction and sovereignty, creates tensions and compromises criminal processes. For instance, the ICC's inability to compel witnesses is a significant diminishment of its enforcement powers. The vagueness and idealistic language in some international human rights commitments make it uncertain whether they are legal obligations or merely moral aspirations. The debate over soft law versus hard law also contributes to ambiguity about binding force. Monitoring compliance, especially for environmental or labor rights, is difficult due to states' lack of capacity, resources, or political will to report accurately or police violations within their borders. 5. Political dynamics and power imbalances. The UNSC, a primary enforcement body under Chapter 7 of the UN Charter, is limited by the veto power of its 5 permanent, unelected members, raising questions about its representativeness and legitimacy. This can hinder its ability to prevent or quickly stop conflicts. While sanctions are used, they can be slow to work, disproportionately affect ordinary civilians, and their effectiveness is contingent on political leaders being responsive to their electorates. Their application can also be uneven. The classic enforcement mechanism of self-help, which in its most severe form involves reprisals, is problematic. International law now largely prohibits armed reprisals, but economic countermeasures, while permissible, must be proportionate. International criminal tribunals, like the ICTY, have faced criticism for perceived selectivity and bias. Undermining their legitimacy, states are often reluctant to submit disputes to international courts due to fear of unpredictable outcomes, loss of face, or perceiving it as an unfriendly act. The dependency of international courts' jurisdiction on state consent is a significant defect. This can allow states to break international law with apparent impunity, leading to injustice and cynicism. In conclusion, these challenges highlight that international law's enforcement relies on a complex interplay of state action, international cooperation, the influence of non-state actors, and continuous adaptation within a fundamentally sovereign state-centric world order.